motion we are here on is the state's motion for protective order regarding witness interviews. I'm going to start with the anti-SLAPP motion.
And there's a third one. I put in a motion to dismiss the trespassing charge.
Oh, okay, that's right. Thank you for reminding me. Okay. There's also a motion to dismiss trespass charge under ARS 13-1503. And the argument there is that there was a lack of evidence, violation of due process, and violation of confrontation clause. Right. Yeah. So I'm still going to start with the anti-SLAPP motion.
I got a housekeeping thing real quick. Is that okay?
Sure.
Okay, on the 122, because I put in a motion, I put it in last time, a motion just to notify you, and
okay.
then
so Mr. Brown?
Yeah.
Here's the deal.
Can I finish though?
Nope. Here's the deal. Because I've already ruled on your motion.
No, you didn't.
Yeah, I did.
Okay.
I've ruled on it multiple times. I'm not ruling on it again.
Okay, can I finish though?
Nope. You're going to listen. No, Mr. Brown.
I need a hearing. You can't do it without a hearing.
Mr. Brown.
So if you can't follow the law, ma'am, you're going to have to recuse yourself. Because this is the Arizona Supreme Court Rule 122. And it says that I need a hearing if you're going to deny it.
No,
you can approve
it does not.
Yes, it does. Can I read it to you? 122.
No, Mr. Brown, I have read Rule 122.1. I have ruled on your motion multiple times.
No, you didn't.
Yes, I have.
You ruled and said I couldn't live stream. You didn't rule on what I asked. That's why I put in another motion. I asked the audio and video record, and you have to, right here it says you have to have a hearing. You can't deny it without a hearing. Especially since the, yes.
Stop. Here's the deal. I already denied you the right to video record.
Without a hearing.
I denied it based on your motion.
Without a hearing.
We've had multiple hearings where you have raised this.
Nope.
I am not.
We didn't have a hearing. We never had a hearing. And I get to discuss my issues.
Mr. Brown, I am not revisiting this issue. I have already ordered you may use a personal audio recorder only. No cell phone, no video. It may not be live streamed.
Okay, I understand that, but
okay.
You have to have a hearing. Right here it says you have to have a hearing.
Any disagreement you have with my interpretation of that rule, you may take up with the higher court if you wish to file a special action. But my ruling stands. There will be no audio recording.
No video.
I'm sorry, no video recording.
Yeah, you're really confusing me.
Mr. Brown, stop.
So, yeah,
Stop.
all right. So let's just go ahead and we're going to end this. I mean,
no, we're not, because I am not. An adverse ruling is not bias. It's just an adverse ruling, and you can disagree with my interpretation of the rule, and you can file a special action if you disagree. However, my order is going to stand. There will be no video and no live stream. You may audio record with a personal recording device only. No cell phone.
The judge
Until the rule changes, that is my standard.
Until what rule changes?
Until something happens with 122.1.
No, this is 122, ma'am. 122.1 is in the courthouse. 122 is in the courtroom. And it says right here, the judge will promptly hold a hearing if the judge intends to deny the request or a portion of the request. And if you intend to deny it, you have to promptly have a hearing. You can't do it without...
This is your hearing. I'm ordering no.
I didn't even get it to make my stance.
You just did.
I wasn't done.
You just did.
I did. I just told you that
Mr. Brown, we're here on your motion.
Yeah, I just told you I'm required to have a hearing.
Mr. Brown?
And then up here...
Mr. Brown, put it down, right now. Put the paper down. Thank you.
We're not going to get nowhere today, so we probably should just end this.
No, we're going to go forward. An adverse ruling is not bias.
I didn't have a hearing.
If you disagree with me, you can take it up on special action. I am denying your request to video or live stream. You may use a personal recording device only, and it cannot be live streamed.
Hey, Judge, nothing on the court's rulings or anything Mr. Brown is saying. I just received a report that astonishingly, Mr. Brown's mic is not picking him up very well. I don't know how that's possible, but reorientation.
I don't even know what you're talking about.
The microphone.
This mic.
Yeah, for some reason.
Make the right call.
All right, sir, I'm ordering you to step out if you cannot be quiet.
He's bothering me.
You're bothering me.
I just asked her if it was live stream.
Just,
All right,
I don't get any, this is
Stop it.
crazy.
It's all set up.
This is set up.
Fucking courts.
all right.
This is a setup.
No, it's.
You're setting me up, ma'am, you're setting me up.
Mr. Brown, the fact that I have issued my order does not mean, just because you disagree with it, doesn't mean I am biased against you.
It does mean that.
No, it
This
doesn't.
statement is biased against me.
Mr. Brown.
You ruled without hearing me.
Stop it.
You ruled without hearing
Okay,
me.
so in the part of the defense motion to dismiss based on the anti-SLAPP statute.
Oh, you talking to me?
No, I'm about to make some decisions. Court has reviewed the defendant's motion.
Here, I have more to
It is
add.
not your turn yet, Mr. Brown. The court has reviewed the defendant's motion. The court also received a thumb drive with 4 videos, a copy of a pocket constitution, a handwritten note from Mr. Brown, and a copy of a complaint and request for injunction filed in the United States Federal District Court against a number of other judges and other officials in Pima County that has nothing to do with this court. The court is disregarding the complaint and request for injunction because it is not relevant to this case. The court has considered the video evidence. The court did not receive any additional affidavits under ARS 12751. A motion to dismiss needs to be filed within 60 days after service of the complaint or other document on which the motion is based. The court takes judicial notice of its file, which shows that the complaint and citation was issued on February 18th, 2025. This motion was filed on July 25th, 2025. The defendant did not request leave of the court to file an untimely motion. The motion is denied.
Ma'am, can I?
No. Additionally, as to the prima facie case, the court finds that the citations are for 3 misdemeanor charges. The first one is for criminal trespass, the second one is for disorderly conduct, and the third count is for misdemeanor assault with injury. Based on the court's review of the videos submitted by the defendant and the defendant's pleadings, the court finds, as well as those statutes that were cited, the court finds that the statutes are content neutral in character, and they're therefore subject to intermediate standard, or finds that they amount to reasonable time, place, and manner restrictions, as well as the administrative order of the Pima County Court that precludes, as well as Rule 122.1, which place restrictions on the manner and time and place that recordings may be made. The court finds that the evidence shows that the defendant was at the Pima County Justice Court for a legitimate purpose to begin with, in which he had a court hearing concluded, and that concluded the legitimate purpose for being lawfully on the property. After that happened, the court finds that Mr. Brown remained on the property, that he was live stream video recording people who were going into the courthouse without their permission to do so, and that he was asked by court security to leave the premises or stop recording. He refused, and that would be the threat.
That's a lie. I object to that.
You can object, and these findings are based solely on the issue of the prima facie case. They will not be used for any purpose in any future proceeding. The court finds that as a result of the continued presence and recording of people who did not give their permission to be recorded, that Mr. Brown then refused to comply with requests of court security to leave the premises based on the video evidence Mr. Brown submitted. Therefore, the court finds that he has not satisfied his prima facie case of showing that there was, under Rule 1271, he must show a prima facie case that the legal action brought here was substantially motivated by a desire to deter, retaliate against, or prevent the lawful exercise of a constitutional right. The court finds that he has not satisfied that prima facie case, and a motion to dismiss is denied. The motion to dismiss for the trespass charge under ARS Chapter 13-1503 for lack of evidence, due process violations, and confrontation clause violations is also denied. The court finds that there is probable cause sufficient to go forward with the charges. The court finds no violation of due process, and the confrontation clause is not relevant yet. We have not gotten to any kind of hearing where confrontation is at issue. All right. Those are the defense motions. The court's prior ruling that one denying any further requests for video or live streaming from inside the courtroom are affirmed. As for the state's motion for protective order or witness interviews. First of all, what I want to know, Mr. Brown, is what witnesses are you seeking to interview?
All the witnesses on this list, and
I don't have the witness list. That's why I'm asking you.
okay, yeah. So Kevin Luckenbaugh,
Okay.
Richard Lopez,
Okay.
Francisco Vasquez,
Okay.
Stephen Mythen,
M-Y-T-H-E-N. Okay.
Richard Tracy,
Okay.
and Brandon Kimmel.
All right. And I missed one of the names. I have Richard Lopez, and then I missed the person right after that.
Francisco Vasquez,
Oh.
Vasquez.
All right. I have 5 witnesses. I think you read.
Oh, yes, but that's, and then at the very top, Detective Klein Klein line, C is at the top of that list, C, Kleinlein. David Glenn.
David Glenn.
And then Sergeant Sachs.
Well, now you're adding more names. Okay.
That's the Tucson Police Department ones. It's not on the witness list, but Sergeant Sachs is the one that did the probable cause.
Okay, so first of all, I had missed one of the names you read, and you haven't read that one off again. So
Yeah, I just added that one, and I got one more to add.
Okay.
But,
go ahead.
and then Officer Lee. I have to finish her
Okay, so
interview. So you got all the ones. You got Kevin Luckenbell, Richard Lopez.
No, okay, so it was Kevin Luckendow. That was who I
Yeah.
was missing. Okay. All right. Can you spell Mr. Luckendow's name for me?
Judge, I have a printout of the state's witness. That doesn't include everybody that Mr. Brown has, but would that be helpful to the court?
That would be helpful. At least then I've got the
Yeah.
names.
Luckenbill.
Oh, Luckenbill. Okay.
Luckenbill. Yeah.
All right. Are there any other witnesses you are seeking to?
So you got so Sergeant Sachs and you got Lee, and then and you got Richard Tracy, and you got Brandon Kimmel.
Yes. Okay.
Yep, those are all the ones I need to interview.
All right. So, Mr. Brown.
And I'm going to put a notice I'm going to appeal your decision on the,
You're going to file a special action, I understand.
no, appeal on the decision you made on
Oh, appeal on the decision on the anti-slap. Yep.
the anti-slap, yes. Because it says right there, the date or other things that contribute to it right after that. So the things that contribute to it happened in September, so I'm well within the time. Because it says right in the, ooh, does that feedback me?
Yeah, that feedback is.
Sorry, the microphones are.
The microphones are very strange today, I apologize, they've been like that. So, the deal, and, hold on one second.
Under D, it says that.
Right, so the.
I'm within the 60
Okay,
days.
so, no.
Yes,
So
I was.
Listen to me. The motion to dismiss or quash may be filed within 60 days after service of the complaint or other document on which the motion is based, or in the court's discretion at any later time on terms that the court deems proper, including a later time after there is actual notice of parties' misconduct. You did not ask me for permission to file this motion late. You didn't ask. I didn't give any I did not exercise any discretion to grant you permission to file that motion.
But it wasn't
You didn't
late.
ask for it. Yes, it was. Because the only time after 60 days is if, in my discretion, I allow you to file it. You didn't ask. It is untimely. All right. You may, of course, appeal if you wish. All right. Now, let's talk about the motion for protective order for witness interviews. So, what is the scope of the state's request here?
Judge, if I could sort of articulate the state's idea, which would be to allow, of course, Mr. Brown to interview the relevant witnesses for the case. The state would be seeking the court's permission to do that in an empty courtroom, probably in the presence of at least the state's investigative officer, Detective David Klein, who was not involved in the original part of the case, but he's subsequently been added on. The purpose of this being to narrow the interview to the events of the day, relevant questions about training and experience, and what have you. The state has a couple of exhibits I'd like to show for the court, or at least articulate. Mr. Brown has already interviewed Officer Monica Lee on a telephonic interview that went for 1 hour and 45 minutes, at the summation of which Officer Brown terminated the interview and Officer Lee terminated the interview. And Mr. Brown said he was just a third of the way through. That's one part of the problem, is just the scope and the length of these battery of questions. But the second, I think, comes to more to light if the court hears the manner in which these questions are asked, the kinds of questions that are asked. They're inappropriate. They're asking for legal conclusions. They're browbeating. They're not accepting the answers that are being provided. It's abusive under the state's motions that articulate a number of reasons why the court has the authority to prohibit that kind of interview. Certainly, Mr. Brown has the right under Rule 15 to ask his questions of witnesses about what was going on, what they saw, what they perceived, what happened, what their training experience is. But state's happy to play a couple of less than 5-minute clips out of that hour and 45 minutes to give the court a sampling of what an interview with Mark Brown is like. In the state's motion, it also contained the link for Mr. Brown's YouTube station. You can watch the whole hour and 45 minutes if anyone could, other than being compelled to, sit through that. But this is not something that witnesses should be subjected to. It's circular, abusive, irrelevant, a whole list. It would be apparent if I played just the sections that we have.
All right, I will allow you to play that section. Do you have an exhibit marked?
I do. So State's Exhibit 1, this is from Mr. Brown's own interview. Actually, they're in the wrong order. That's supposed to be here. State's Exhibit 2 is an excerpt from the interview.
And this is an excerpt of the interview with Officer Mayhew?
Yes, Judge.
And this is available publicly on YouTube?
Yes, Judge. That's how I made the excerpt.
All right.
There we go. The volume, I have my volume turned down. So this is State 2, titled Brown Interview Officer Lee Extract.
Okay.
I did, it was this morning. The fact that you were refusing to leave. Okay, is that a fact?
Oh, and Judge, the reason the video of the incident is playing is that's how Mr. Brown has it on his YouTube station. I think the court already seen this.
Yeah, that was one of the videos that Mr. Brown submitted. Yes.
What was that? What did you say?
The reason there's a video playing in the background of the audio interview is that's the way it's presented on your YouTube station.
The fact that you were refusing to leave. Okay, is that a fact? You just said fact. Okay. The probability that you were refusing to leave after being asked. So, that's this early? So you're talking about trespassing 15-02. That's in that. But you didn't charge me with that, man. Do you understand that? Okay, so that can be either dismissed or amended. Okay, but you're the one that put in the probable cause statement. You're going to be up on the bench explaining this. I'm going to have some serious questions. So if you can't answer the simple little question when we're on the interview, you're sitting at your desk, how are you going to do it in front of the courtroom? Okay. I'm asking you, how are you going to do that? You're agreeing with me, okay? So are you gonna? Yeah, what is your question? Are you gonna ask the prosecutors to drop these charges?
a second?
That's the whole extract, Judge.
Yeah. The gentleman who was removed is recording from outside into the courtroom. He is not to be live streaming from anything that is inside the courtroom. Thank you.
What? State moves it, that state's position.
I hear he's listening to a video. I hear his video from here. We have a guy being arraigned in Texas, and that's what he's watching. I was trying to watch it.
No, he's pointing the camera directly at my face. Okay.
I heard the,
You know what, Mr. Brown? Not part of this proceeding. Okay, Mr. Franklin.
And Judge, it's the state's position that the length and nature of these interviews is not to obtain information for cross-examination or for use of trial. It's to generate content for the YouTube station. In support of that, I have State's Exhibit 1, which is captures the post-interview. Should I wait, Judge, or proceed?
Go ahead and proceed.
Captures the very, very tail end of the interview, and then Mr. Brown and I, another party, presumably Mr. Cipollini maybe, but it captures the nature and purpose of the way they conduct the interview.
do I get to respond?
Yeah, you will have a chance to respond after he presents his case.
Hello? Was that in the interview? I didn't even get to a third of it. I think this girl, yeah, I think she's dumber than the folks who got her already her oath. That idiot. I think she's dumber than Chandler. I couldn't get the interview.
James said she fled the
I object, the interview's over, I object to this.
Well, I can't believe that bitch stuck around for that long.
I object to
Every
this.
one of these relevant
What,
questions.
the interview's over.
On the state.
But what's the
Your
difference?
objection is overruled. It is relevant to the motion. Go forward, Mr.
How is that relevant?
Because it has to do with the limits that they are requesting and the reasons for the limits. It is relevant. It is, go forward.
And Judge, if I may, a couple of things. The court can take note of the time stamp on the video. It's 1 hour and 45 minutes in. That's when that interview ended. And in addition, at the very tail end, you hear Mr. Brown talking about the kinds of questions you can ask Officer Lee, including ones that involve legal conclusions, which are apparently not questions for fact-based witnesses. So it gives the court a taste of the litany of questions that were asked of Officer Lee.
I couldn't get the interview.
James said she fled the scene. Oh, I can't believe that bitch stuck around for that long.
Every one of these were relevant questions. She can't understand she's not going to be able to say that I can't ask that question about the statute.
Right.
I mean,
State's position, of course, would be asking the fact-based witness for
And they was all relevant
All
questions.
right, Mr. Brown, it's not your turn. Mr. Franklin, can you repeat that for the record?
Yes, Judge. As to the last few seconds there, Mr. Brown's statement about being able to ask officers about what, for instance, disorderly conduct means, calls for a legal conclusion, which is an objectionable and inappropriate question for a fact-based witness testifying. So, if anyone wants to endure the 1 hour and 45 minutes, you'll hear a barrage of questions asking about what the statute means, to read the statute, to read the statute again, it goes on and on like that, Judge. These aren't questions that anyone is asking in order to elicit evidence for cross-examination or for presenting a trial. I think it was an attempt just to wear down Officer Lee, who quite nobly stuck it out for 1 hour and 45 minutes, but then eventually terminated the interview. What the state's seeking, Judge, is limited scope of questions related to the incident or training experience of the parties involved, and a finite time on the questions within a reasonable nature. This whole incident with the conflict with security, with Mr. Brown Courts seen, I think, in some of the video footage, it was about 2 minutes, thereabouts, maybe 5 if you catch the stuff at the beginning and the end. Most of these witnesses were only involved for that direct component there. It shouldn't be an Officer Lee, for example, based her citation decision based on the video that Mr. Brown, or for the security footage, sorry, that was available in Justice Court, Mr. Brown has a copy of, and statements from the victim, Mary Jane April. That's her entire involvement in the case. That's all she knew was what the Justice Court video was and what Ms. April told her. That shouldn't be an hour and 45 minutes of questioning. The state objects to Mr. Brown having a free hand to abuse witnesses in this manner.
Okay. Mr. Brown. No.
Okay, first of all, it was an hour and 45 minutes of her. You're going to listen to that whole thing. If you're going to have to listen to the whole thing now that he did this, it was an hour and 45 minutes of her saying she can't get her computer up. And I guess, is it up yet? No. For an hour and 45 minutes, she could not bring her computer up to look at the only video, and she couldn't remember none of it. She couldn't remember none of the video, and she couldn't bring it up. And she kept saying, the video has no sound. She kept saying, I was asked to leave. There's no sound.
Okay, stop. He is once again recording me. At this point, he is in contempt of court.
Okay. Is that going to be removed from the?
Yes, please. I do not give my consent to being recorded. All right, we can go forward, Mr. Brown. Go ahead.
Oh, I get to go on? I thought you stopped me. So anyway, so yeah, that was an hour and 45 minutes. It started right away. I asked her to bring up, probably 30 minutes in, I asked her to bring up the video, because that's all she's got. There's no sound on the video. And she kept saying that I was asked to leave. Well, I wasn't asked to leave like that. And she kept saying I refused to leave. And that's all not fact, or it's fiction. It ain't true. Everything she was saying wasn't true because she didn't have no audio at all. And she couldn't bring up the computer. Like 5 minutes in, I'd say, you bring it up? No, not yet, not yet. All the way to the end. He skipped all that, but all the way up into the end, why do you keep looking at him like that? That really gets me, because you're looking at him for answers. And that's what happened with Judge Klotz.
I'm not looking at anybody for answers.
Yeah, okay. That's my opinion. And since you won't let me record, I have no,
Stop it.
So anyway, back to this here. Okay, first of all, this motion that he wrote is supposed to be based on facts. Right away, statement of facts. Now, I'm going to do a bar complaint on whoever wrote this. I'd like to do it on him because he didn't even write this. But defendant was arrested February 18th, 2025 for criminal trespass, disorderly conduct, and assault. I was not arrested on February 18th. That's what my whole anti-SLAPP was about. I wasn't arrested then. I never was. I was assaulted by Mary Jane in the public area of the Pima County, or it's called the what's it called?
Consolidated Justice.
No, it's called out on the front building.
It's called the Pima County Consolidated Justice.
No, it's the Public Works. It's called Pima County Public Works Complex, something like that. It's not, the Justice Court is part of that. See, but the whole place is a public building. It has the recorders in there.
I know it's in there.
So it's not called a court. Out in the public area, and 122.1 covers that, and it has a definition of a courthouse. And the courthouse, if it's used for other things, it says right there in 122.1 that any area, if it's used for other purposes other than the courthouse, any area that's for the other purposes, it doesn't apply to 122.1. And 122.1 also talks about I have to get consent. And here's the main part that everyone's missing on this. 122 122.1 says that I have to get the consent from any person, and then it goes in the definitions in 122.1, and then it gives a couple definitions, and it says all the definitions on 122 apply. Okay, so the definitions on 122B, number 6 is a person. Okay, so a person includes an individual and any organization except the court. Okay, so except the court. I can record court.
So,
According to this 122.
Mr. Brown, we are not here to decide the merits of the state.
Well, that's what you're doing.
No, I am not. Right now, we are here to decide whether reasonable restrictions will be placed on witness interviews for purposes of pretrial discovery only. I'm not here, this is not your trial. This is not the time for you to present evidence about the facts of the case. This is a time to present only an argument about why you are opposed to reasonable time, place, and manner restrictions.
You just said I violated that. You just said I violated that.
No, you're not listening.
I am listening. You
No,
ain't listening.
Mr. Brown, we are here only, right now, the issue on the table is whether I will grant the state's motion for protective order to limit pretrial
Okay, can I finish then?
discovery. No, because your argument was not relevant.
I'm still talking about this. The statement of facts. The statement of facts is everything is a lie on this motion. So, and it's under statement of facts. It ain't a fact that I was arrested on February 18th for criminal trespass.
Okay, so
that's not a fact at all.
You received a citation on February 18th.
And Judge, sorry to jump in, but I would actually have to agree with Mr. Brown that that is an error. The incident's from February 18th, but it appears the citation is July 28th.
The citation was July 28th.
Or not July, May 28th, 2025.
Yeah, he's wrong in it. I think it's May 15th.
And
because it was at my court date.
The court date was May 28th.
Yeah.
So he had
oh, that's your court date. Never mind. I'm reading the wrong part of the
The
citation. May
citation
15th.
was issued on February 18th. The court date.
May 15th was my court date in Justice Court.
Okay, so stop. Just a minute. Okay.
Sorry.
He had a February 18th citation and a court date of May 28th. Unless there's some other date that is not in the court's file, those are the 2 dates I have.
Yeah.
Well, if I could, Judge,
Yeah.
my apologies, I did misread the court date down there. Yeah. So the incident is from February 18th.
Right?
The court date, as the court pointed out, was May 28th.
Right.
But I believe that he was cited based on the report from Sergeant Sachs on May 15th. So at a later date.
Yeah.
So he was cited on May 15th.
That's my understanding, yes.
Okay, so the motion, I'm not going to change my decision on the anti-SLAPP motion. It was still filed outside of that 60-day window. You did not ask for leave of court to file it outside of the 60-day window. All right, and I also find that you didn't satisfy your prima facie case. All right.
Can I answer on this motion?
I would love for you to answer on that.
So anyway, so all this facts is wrong. So I was not arrested on February 18th, and I wasn't even arrested on. And then they put it out on the 22nd of April is when they refiled the motion, and that was 1 week after my anti-SLAPP.
Wait, no, hold on. There's nothing in my file between February 18th, when it happened, and May 28th, which was your arraignment. I don't know what.
May 15th.
May 15th was the day you got served.
And I think that was his arraignment in a different matter at Justice Court.
That has nothing to do with this case. You were arraigned in this case on May 28th. You may have been served on May 15th in Justice Court. That's the date we're going to use as the date of service of the citation and complaint. That doesn't have any, I don't know what you're talking about as far as April, but April may be related
Yes,
to a different
that's what I said.
case.
April 22nd, yeah. That's correct. They put out the order on April 22nd. I agree with that.
April 22nd is what day?
A stop and arrest.
Okay, so there was a stop and arrest order
Issued.
issued on April 22nd. You
Yeah.
got served on May 15th at Justice Court, right?
Yes.
Okay.
I wasn't arrested, I was paper served.
That's the same thing as an arrest.
Yes.
It's still an arrest. You don't have to go to jail to be arrested.
So this thing is still based on,
No, okay,
Yeah,
no.
so-
So you still haven't addressed the substance of the state's motion?
yes,
You haven't.
yes, let me finish, I'm not done yet. So anyway, so when I did that 1 hour and 45 minute video, she couldn't bring up the thing. So that's why I have to do another interview with her. She didn't even look at the evidence. And she kept saying that I was asked to leave that I was asked to leave, and I refused to leave. She kept saying that, because that's part of the thing. I refused to leave.
That is an allegation that the state is making, okay? And they will have to prove that at trial in order to obtain a guilty verdict. But that doesn't change that that is what she is saying that her testimony would be. So once you've gotten that answer, that's the end of that question. She says that's what the allegation is. You get to dispute that. You don't get to change her mind. That's not how courts work.
And I wasn't doing that.
Well, no, clearly you didn't change your mind. However, you don't get to badger her into changing.
And I didn't badger her.
Okay, so Mr.
She ended the interview, I
Mr.
didn't.
Brown, yes, after an hour and 45 minutes.
Of her not being able to look at the video. She couldn't bring up her computer because she said her computer didn't work or whatever.
Mr. Brown, did you live stream your interview on the internet?
What does that matter?
Because it's not allowed. It's not allowed for pretrial discovery.
Okay, then I won't do it anymore from here. I didn't know I couldn't live stream my interview with the Tucson Police Department. This is Tucson Police.
Right,
You know?
but this isn't.
You bring them in here to harass me every time I come here. This
No, I
happens.
bring them in here because one of the times you came in here, you got your fist so close to my face, you almost punched me.
That's a lie. I never put my fist in your face, ma'am. And if I was recording this, I could prove
Mr.
that.
Brown.
So you're making false allegations against me.
I didn't do anything other than say, I want someone in here. That's it. That's all I did. I didn't bring charges. I didn't charge you with contempt. I didn't do anything other than say, I'd like someone in here for me, please. That's all I said. So, here's the deal. The question we're raising, the state has raised, is they've requested some limits to put on interviews so that people aren't concerned about coming to court and that they're not concerned for their safety because interviews related to a case are being improperly put on the internet. Now, these aren't interviews you're doing with the police department as a member as a journalist. These are case related, and there are rules of criminal procedure that guide what you're allowed to do with them. And you have not been complying with those rules. That's different than if you were interviewing.
What rule did I break?
Okay,
You're not telling me.
I just did. You put it on the internet.
Where does it say I can't do an interview with a Tucson police officer?
Rule 15.4D. Counsel in State versus Chavez.
Can I have that?
It's in the state's motion. The court reminded counsel that under Rule 15.4D, discovery materials, including witness interviews, are considered confidential records. Any materials furnished to a party under Rule 15.4D or counsel under Rule 15 must not be disclosed to the public and may be disclosed only to the extent necessary for the proper conduct of the case. That means You're not putting it on the internet. Those are confidential pretrial disclosure materials. These aren't interviews that you are conducting with police officers pursuant to something through a FOIA request or through the Public Information Office of the Police Department. These are interviews of witnesses in a criminal court case. You don't get to put them on the internet. They're not available for that purpose. That is not the purpose of these interviews. You don't get to badger them for 2 hours.
I didn't badger him, that's his words. You have to listen to the whole thing. She couldn't bring up the video. That's why it took so long. If she would have brought up the video, that would have been done a lot faster. She couldn't bring up the only evidence she reviewed on me was the video. That's all she reviewed, and there's no sound on it. So she said, I denied. She kept saying, I denied. So I was going to be...
Here's the issue, Mr. Brown, is that in a misdemeanor case, the state gets to present their evidence at trial, and you can cross-examine her at trial about things that are admissible. When you are doing these pretrial interviews, you're allowed to ask them questions about evidence that is admissible or likely to lead to admissible evidence. Her opinion about what a statute says is not admissible. You can't ask her. You are limited to evidence that is relevant and admissible or likely to lead to relevant and admissible evidence. And it can't go on the internet. That's the rules. Those are the rules of criminal procedure. Those are the rules of evidence that apply to your case. This isn't a FOIA request. All right, I am ready to rule at this point in time. I am granting the state's motion for protective order for witness interviews. Here are the parameters. Mr. Brown, of course, you may continue to interview with the witnesses on your list. However, you're limited to no more than 1 hour.
Prior restraint.
You are limited to no more than 1 hour of questioning. You are not permitted to live stream the interviews. You are not permitted to post the interviews on the internet. Your questions are limited to questions that are relevant and admissible to the 3 charges or likely to lead to relevant or admissible evidence. Those 3 charges are criminal trespass, disorderly conduct, and assault with injury. They are all misdemeanors, and your questions are limited to the facts relevant to the elements of those crimes or your defenses. You may not ask the fact witnesses for their opinions or understandings of statutes. That is not admissible, and it is not going to lead to admissible evidence. All right, as far as a time and place.
Judge, if I could ask, will
Yes.
one of the questions not be formulated in a mocking or abusive manner? At one point, he asked Officer Lee, whether he or not.
Yep. No insulting questions. You have to treat people with respect, sir.
I asked her to read a simple thing, and I just asked her, no offense, I said, she couldn't read nothing to me, so she couldn't read one little sentence.
She doesn't have to read to you. She does.
I was asking her to read her own report, what she said.
Okay, so again, no mocking, no insulting, no posting on the internet. 1 hour, we will get the interviews scheduled and make a room available in the courthouse for you to conduct those interviews. So
Which courthouse?
It'll have to be this courthouse.
Yeah, so that's my other problem. All these guys are government employees. Mm-hmm. Every one of them is a government employee.
Yes.
So, so they're, you're talking about right to privacy. If I should be able to go over there and do it, and then I should be able to set up the interviews with them. They're witnesses. They're not victims. So I should be able to go over there. I should be able to call them and go over there and do the interviews. The only reason I can is because of you two.
No,
To the Justice Court.
don't point your finger at a judge.
The reason is because of you two is why I can't go to Justice Court without getting arrested. And it's a public building. You are keeping me from a public building, ma'am. I should be able to go do this. These interviews should have been way over with. I should be able to go over and do the interviews. And
I agree, they should have been way over with. Unfortunately, because you have not complied with the rules of evidence and the rules of criminal procedure, you're here on this motion to put some restrictions in place so that you can complete them without witnesses being intimidated by.
I was calling for 2 weeks, twice a day, to set these interviews up. Right after we left here, the same day I started to set the interviews up. So the same day, twice a day, he wouldn't even answer the phone. So, and they're all government employees. Every one of you government employees are getting paid out of taxpayer money. I'm not. I'm the only one on this whole list that ain't getting paid by taxpayer money.
No, you're getting paid off of your YouTube channel, which is
I am.
what you told me.
Okay, I never told you that.
You did. You made an argument to the court at the hearing held on.
So what proof you got? I got paid for my YouTube.
Well, I'm
You said
taking
that
your
at my
word
last.
for it, sir, because you argued to me that I needed to let you return to the justice court because I was preventing you from making your videos, which is how you made your living, which makes it commercial.
Okay. Why do you keep looking at him again?
I'm not.
Yes, you are, ma'am. I wish I could record this. You're looking for him for answers on everything. And you did that last time, too. All you do is look at him for answers. And that's what he did with Judge Klotz, back then. He came, this same...
So, Mr. Brown.
Kevin went on the...
Here's the deal. I'm not going to listen to you insult me. I'm not going to listen to you insult Judge Klotz. I'm not going to listen to you insult other people. We are, however, going to grant the state's motion, and I am placing reasonable restrictions in place.
I ain't getting a fair trial in here. There ain't no way I'm getting a fair trial with you. Not a chance.
You keep telling me.
You're biased. You're biased. And this thing started with this, was where you're biased. They didn't object to that. I mean, you put a whole page and a half of things, That's showing your bias. That one paper shows your bias.
No, that was actually for your benefit, so that if you decided you wanted to appeal or file a special action, you would have the ability to do so.
But it says that you have to have a hearing. We never had a hearing on that at all. You gave your answer at our second court date, and you
Which
never...
was a hearing.
You didn't... Yeah, but you gave the answer before the hearing. You didn't have a hearing to hear my side. You granted it, and they didn't object. The state... Kevin even says I could record him. He told me I could, so he didn't object, and they didn't object on that. You objected.
Okay, so Mr. Brown, we're not here on that motion. If you wanted to take that up, you need to file a special action.
Yeah, it'll be too late. It'll be over with, so what's the matter? If I could... What's the reason? You're a public official. Why can't I record you? Why can't we...
You're not just recording...
What you're doing is to me.
You're not just recording me.
Okay.
You're also recording other people who are in the courtroom.
No, I could face it right there and record you.
But
that's what Judge Klotz let me do.
Okay.
That's what he let me do, and he let me record him last time.
Okay.
I don't think I did, but I don't.
No, we're not doing that.
Judge Klotz did. Judge Klotz ruled that I couldn't record the cops or anyone in the audience. That's all he did.
I think I did include the prosecutor as well, and I was on it, but I didn't care.
Also, Mr. Brown, I allowed you to record your hearings, but you can't do it live streaming. And you can't do it with your cell phone.
Okay.
That's what the rule says. I already said you could use a personal audio recorder to record your hearings if you wanted to.
But I wouldn't record audio and video, and I didn't have a
And
hearing.
the answer is no for that.
But I didn't have a hearing.
Yes, you did, because I said no. multiple times.
In writing.
Fourth time, I have said no.
No, you gave that to me in writing before the hearing, ma'am. I didn't have a hearing on that. You gave me that answer in writing before the hearing. You know?
File an appeal, Mr. Brown. In the meantime, we're going
Yeah,
to
just because you're biased against me. You know? Yes, you are, ma'am. You are. And I'm going to leave it at that. You are.
Not the same thing as bias, Mr.
You were biased against me, and I ain't going to get a fair
We
trial.
need a separate hearing, Mr. Brown, and you need your paperwork, and I need to fill this out.
And Judge, not that I have any inclination to extend the hearing at all, but I think there will be some issues with some of the witnesses, and it makes sense probably to address it now rather than later.
All right, let's talk about it.
Everyone who's on the state's witness list that provided to Mr. Brown and to the court certainly makes sense to the state, and we make them available, except of course for the victim. Detective David Kleinlein has come in after all of this, so I'm not sure. He'll be present, I guess, if Mr. Brown wants to ask him some questions. I have no idea who Brandon Kimmel is.
No. He is the one that sent Mary Jane after me. He's the head of Justice Court Security.
Okay, then who's Richard Tracy?
Richard Tracy is the head of security at Superior Court.
So,
and then Mary Jane's at Superior Court too.
So my understanding, Judge, well, let me dive in a little further actually for us. So I think there's Sergeant Ryan Sachs, who makes sense to the state for Mr. Brown to interview because there is instructions from Sergeant Sachs to Officer Lee, so that makes sense. Officer Lee has subsequently retired, so the state has no control over where she's at or no means of contacting her. I believe the same is true for Richard Tracy, not that he was ever in the city prosecutor's sphere of influence. Neither is Brandon Kimmel, and David Glenn. I believe David Glenn. David Glenn, I have no idea.
He was on that.
David Kleinlein.
Yeah, I think I said that.
Okay.
He's on that.
Yeah, sure. Okay.
Was that guy? His name was David. I can't remember now.
Yeah, his first name is David.
Yeah.
Last name Klein.
Yeah.
So, in the event, on that list that Mr. Brown went through, I have no mechanism for Richard Tracy, Brandon Kimmel, or former officer Monica Lee, who there was an hour and 45 minutes of interview with Officer Lee.
She didn't have the video. So all the questions I asked her about the video, and most of that was in the 145, she couldn't answer it because she couldn't have access to the video. I probably 20 times I asked her to answer. Oh, I still can't get it up. She acted like she kept trying, but she never did. She just filibustered. And that's what they're going to do when you give me an hour. They're going to filibuster, and then I ain't going to get no answers. And that's what she did for an hour and 45 minutes. Okay. And you ruled on that without listening to that whole hour and 45, him just playing that little piece.
Mr. Brown, couple of things. One, you spend a lot of time yelling at people, and a lot of that time is time that you could be spending asking actual questions. Number two, just because you have a right to ask questions doesn't mean you have a right to the answer you want. Sometimes you have to accept, I don't know, I don't have it, I don't know, and move on. And when you cross-examine them, you can question them on the fact that they didn't have it or they didn't know, and there it is right there in their report. Those are valid questions, but you can't ask them over and over and over and hope for a different answer. There is an objection in the rules of evidence for asked and answered, and sometimes the answer is, I don't know. And that's a valid objection. So before you go forward with more witness interviews, I would recommend that you take a look at the rules of evidence and look at what the valid objections to questioning are. Because the state's going to make those if you do that at trial. And that's a legitimate objection. So you want to make sure that you have your questions written out and you're following those questions, and they need to be questions
Yeah.
that go to the facts, not the law.
If you're the judge, it's gonna be a lynching, not a trial. So I ain't getting a fair trial with you. There ain't no way. Anywhere in these two courts, Tucson Court or Justice Court, the same thing, because of Tucson Police Department and because of all the security over there and the security here that's been doing this to me for the last 8 years, you know? So I know I ain't gonna get a fair trial here. If something happens over there, they do it here. Something happens here, they do it over there. You know, so only if this gets moved, and that's what my next motion I'm going to put in to change the venue, because I ain't going to get a fair trial here. There ain't no way I get a fair trial with you in the system you guys got. You know, you won't even let me record it, so then I won't even be able to show people how unfair you guys are. So I won't get a show how you look at him and everything. You did that last time, big time. I couldn't believe it. Every time you go to make any ruling, you look at him. He's the one that gives you answer. That's the same thing with, like I said, it happened to me with Judge Klotz too. And he brought up in Judge Klotz that I was making all this money on YouTube. I wasn't even monetized at all.
Okay, so Mr. Brown.
So that's irrelevant. I don't see how you even brought that up on the bench, that I'm making money.
Mr. Brown.
Without no proof.
Mr. Brown, your claim, when you asked me to lift the restrictions on you going back to Justice Court outside of times when you have...
It ain't how I make money.
Mr. Brown.
I didn't say nothing about money.
Yes, you did. You told me that I was preventing you from making your living.
Going over there and holding them accountable.
That's not what you were saying.
Yeah,
What you told me was that I was preventing you from making your living, that this was how you made your living.
Well,
To me.
it ain't true.
Okay, well then you lied to me.
No, I did not lie. I said, I do that for constitutional reasons. I go over there.
Okay,
It ain't to
that's
make
not what
money.
you told
There
me.
ain't no money in that.
Okay,
There ain't no money in it.
all right. I'm not saying it's a good living. I'm saying that the argument you made to me was that I was preventing you from making
Doing my
your living.
constitutional right.
No, that's not the words you
Yep.
used.
But it doesn't matter. That you guys make money. Every one of you guys in here. Everyone makes money. You make money. You guys all make money. I don't make money off this. So you guys do.
So, Mr. Brown-
You guys make money. He makes money. All the judges over there make money. All the witnesses on this list make money. Every
Mr.
one of
Brown,
them.
Mr. Brown, you have misunderstood the reason I mentioned your statement, that was how you made your living, which is that there are different types of speech.
I'm an air conditioning guy, ma'am. That's how I make my living.
Okay.
I'm an air conditioning
Mr.
guy.
Brown, you are interrupting me, and you need to stop. There are different kinds of speech, and they have different levels of protection. And commercial speech is considered, under our laws, the lowest form of speech. There's a definition of commercial speech. And based on these statements that you made to me in court, you gave me the impression that this was about your YouTube channel, and that was how you made your living. That's the words you used. So, if you're wanting to...
So if I misspoke for 1 second, you're going to hold that against me on the trial. So you're biased already.
No.
You're biased in this
Mr.
trial.
Brown.
You are biased against me.
Mr. Brown.
And I can't have a trial with you.
Mr. Brown, you can say it as many times as you want, it doesn't make it true. I am not biased against you. My decision on your anti-SLAPP motion holds no bearing whatsoever on the state's burden of proof or any other issue going forward. It cannot be used for any purpose, and I will not be using it for any purpose.
It's all going to be public record. This is going to be a public trial. So,
Yes.
so I could get the transcripts from you and put it on the internet, just like anyone can from public records request. So what's the difference?
Mr. Brown.
I got it. I know you know my name. Can I get my paper?
Well, I haven't had a chance to write it, so you keep talking to me. All right, give me a minute, and I will get it for you. We also need another court date. As far as the witnesses that Mr. Brown is asking to interview that you don't have contact information for, you have no contact information for them?
Judge, the state doesn't feel like it should be obligated to coordinate interviews for people who are
Correct.
not.
That's correct. I was just wondering if you
Yeah,
have any legitimate contact information. Okay, so Mr. Brown, you can still make efforts to locate those people and interview them. You do have a right to do that, of course, but they won't be coordinated by the state.
But I want a court order. I want a court order to interview all the witnesses on that list, because I want a court order because they're gonna keep,
Well, so if you are requesting to get a subpoena for a deposition, you can request that. But the state is not under an obligation under the rules of criminal procedure, under Rule 15.1. Stop. You gotta stop.
I'm gonna
Mr.
look for
Brown,
him for answers.
it's very uncomfortable to maintain eye contact at all times. And so sometimes I might look over there. It doesn't mean I'm looking at any particular person. It means that I find it really difficult to make eye contact perpetually with the same person at all times. All right, now, under Rule 15.1, the state has an obligation to disclose evidence in its possession. It doesn't have an obligation to go find the evidence for you. If you want to interview witnesses who are no longer employed by the city of Tucson, you are welcome to do so, but you would need to find their contact information, and you would need to do it privately. You can't rely on the state to arrange those for you.
Well, she's, for the probable cause, she's the only one that had the probable cause on the trespassing. So you can't convict me of trespass without her. She's the only one that did it. The other officer, he told her to arrest me for disorderly conduct and assault. It didn't even mention trespass. When I talked to him, he didn't know nothing about the trespass. So you're gonna have to. So my motion to drop the trespass. Did you rule on that? Did you rule on my motion to drop the trespass charge?
Yes, but you didn't raise it based on that issue. You raised it on due process confrontation clause. You didn't. In an hour and 45-minute interview with her, you can certainly subpoena her if you want. Just because the state doesn't have the obligation to locate her for you doesn't mean that you can't request a subpoena and subpoena her to testify.
But if she ain't gonna be here to testify on the trespass, and if the state's not bringing her, then you're gonna have to drop the trespass charge.
Judge, if I may.
Because that was the whole reason.
Could save Officer Lee the experience of doing this again. The state's case is not going to be based on Officer Lee's decision making. It'll be based on the security footage, Mr. Brown's own footage, which was very helpful, as well as the testimony of the people who were there, particularly Mary Jane Averill and the other security folks who are listed in the state's witness list. They're the basis for the state's probable cause to go forward. Everything Officer Lee has, as mentioned earlier, is secondary to your statement from Mary Jane Averill. It's reviewing the video